Hello friends, in today's session we will be discussing Companies Act 1956 in further detail. The previous session dealt with an introductory part of the most exhaustive act. This session you will find me discussing the further topics like Articles of Association, Prospectus, Memorandum of Association and various clauses in it, and Doctrine of Ultra-Vires. Now, let us start with the first topic, Articles of Association. Articles of Association are the integral regulations of the company and are for the benefit of the shareholders. These are the rules and regulations relating to the internal management of a company. The articles define the mode and form on which the business of the company is to be carried on. Articles of Association according to Section 2 Subclause 2 of the Companies Act 1956. Articles means the articles of association of a company as originally framed and altered from time to time in pursuance of any previous company's law or of the present act. The Articles of Association are the rules and regulation of a company framed for the purpose of internal management of its affairs. The Articles of Association of a company are subordinate to and are controlled by the Memorandum of Association. The Articles are framed mainly for carrying out the aims and objects of the Memorandum of Association. They accept the Memorandum of Association as the Charter of Incorporation, and so accepting if the articles proceed to define the duties, rights and powers of the governing body. Companies required to file the articles with the Registrar of Companies. The following are the companies which are required to file the articles with the Registrar of Companies. First, Company Limited by guarantee. Second, Unlimited Company. Third, Private Company Limited by shares. Now, let us discuss the content of Articles of Association. It must include first, exclusion wholly or in part of Table A. Second, adoption of preliminary contracts. Third, number and the value of shares. Fourth, allotment of shares. Fifth, call on shares. Sixth, lien on shares. Seventh, transfer and transmission of shares. Eighth, forfeiture of shares. Ninth, alteration of capital. 10th, share certificates. 11th, conversion of shares into stock. 12th, voting right and proxies. 13, meeting. 14, directors and their appointment. 15, borrowing powers. 16, dividend and reserves. 17, accounts and audit, and lastly, winding up. So, now let us discuss the alteration of Articles of Association. First, according to the provisions of the Act and to the conditions contained in its Memorandum of Association, a company may by passing a special resolution alter or add to its Article of Association. Second, the company must file with the Registrar of Company a copy of special resolution within 1 month from the date of its passing. Third, the altered Articles of Association will bind the member in the same form as the original articles. Let us now discuss the limitation to alteration. The alteration made in the articles will be valid until they fall within any one of the following given options. First, the alteration must not authorize anything expressly or impliedly forbidden by the Companies Act. Second, the alteration must not extend or modify the Memorandum of Association. Third, the alteration must not contain anything illegal. Fourth, the alteration must not be inconsistent with any alteration made by Company Law Board. Fifth, the alteration must be bona fide for the benefit of the company as a whole. Sixth, the alteration must not make the Articles of Association unaltered as it is regarded bad in law. Seventh, retrospective operation of Articles of Association. Eighth, the alteration must not constitute fraud on the minority by a majority. Ninth, an alteration of articles of association to effect a conversion of public company into a private company cannot be made without the approval of central government. 10th, there cannot be alteration of the articles of association so as to compel an existing member to take or subscribe for more shares or in any way extend liability to contribute to shares capital unless he gives his consent in writing. 11th, a company cannot justify breach of contract with third parties or avoid a contractual obligation by altering articles of association. The next topic to be discussed is prospectus. Let us first discuss the meaning of prospectus according to section 2 subsection 36. Prospectus means any document described or issued as a prospectus. Prospectus includes any notice, circular, advertisement or other documents. Any document described or issued as a prospectus and includes any notice, circular, advertisement or other document inviting deposits from the public or for the subscription or purchase of any shares in or debenture of a body corporate according to section 2 subclause 36. A prospectus is not merely an advertisement. A document shall be called a prospectus if it satisfies two things. First, it invites subscription to shares or debentures or invites deposits. Second, the aforesaid invitation is made to public. Now, let us discuss the rules relating to prospectus. First, the prospectus should be in a written form. Second, prospectus must be dated. Third, it must be registered. Fourth, it must be issued within 90 days of registration. Otherwise, the registration is cancelled after 90 days of registration if it is not issued during the 90 days. Dating to prospectus. Section 55 states that every prospectus must be dated and that is deemed to be the date of publication of the prospectus. The next topic that I will be discussing is Memorandum of Association. As per section 2 subclause 28 of the Companies Act 1956, memorandum means Memorandum of Association of a company as originally framed and altered from time to time in pursuance of any provisions of company laws or of the Act. This definition does not give any idea as to what memorandum really is. According to Palmer, the Memorandum of Association is a document of a great importance in relation to the proposed company. It contains the objects for which the company is formed and therefore identifies the possible scope of its operations beyond which its action cannot go. It defines as well as confines the power of company. If anything is done beyond this power, that will be ultra vires the company and so void. Thus, it is evident that the memorandum is the charter and defines the limitation of power of a company. Let us now discuss the requirement to be stated in the memorandum. According to section 1, for the incorporation of the company, there must be at least 7 persons in case of a public company and at least 2 persons in case of a private company. Section 13 requires memorandum of a limited company to contain the following clauses. The first one, the name of the company with limited as the last word in case of a public limited company and with private limited as the last word in case of a private limited company. Second, the state in which the registered office of the company is to be situated. Third, the objects of the company must be separated on 2 bases. The first one, the main object of the company to be pursued by the company on its incorporation and objects incidental to be fulfillment of the main object. Second, other objects which are not included above. The next is the amount of authorized share capital divided into shares of fixed amounts. Fifth, the liability of members is limited if the company is limited by shares or by guarantee. Sixth, in case of companies with objects not confined to one state, the state to whose territories the objects extend. Clause 4 and 5 will not be included in the Memorandum of Association of an unlimited company. In case of a company limited by guarantee, its Memorandum of Association should state that each member undertakes to contribute to the asset of the company in the events of its being wound up while he is a member or within 1 year after he ceases to be a member for first, the payment of debts of the company, second, payments of liabilities of the company, the cost, charges and expenses of winding up, and third, adjustment of right of contributories among themselves, such amount as may be required, not exceeding a specified amount. Now, the contents of Memorandum of Association shall be discussed. There are 6 clauses in the Memorandum of Association under section 13. The first one, name clause. This clause requires a company to state its name. A company, to establish its identity, must have a name, but no company should be registered by name which in the opinion too of central government is undesirable and is identical with or which nearly resemble the name of an existing company under section 20. Every public company must use the word limited after its name, and every private company must use the private limited after its name. Second, the registered office clause. It is a clause which states the name of the state where the registered office of the company is to be situated. The 2 reasons for which the registered office clause is important are: first, it ascertains the domicile and the nationality of the company. Second, it is a place where various registers relating to the company are kept and to which all messages and notices must be sent. The notice of registered office should be given within 10 days from the date of incorporation to the registrar of the companies. The third one, object clause. It is one of the most essential clause in the Memorandum of Association of a company because it is not only depict the objects but also helps in determining the extent of the powers which the company can exercise in order to achieve the object or the objects. Fourth, the liability clause. It is a clause which states the nature of the liability of the members. In case of company limited by shares, the liability extends only to the amount unpaid on the shares taken. In case of a company limited by guarantee, the members are liable only to the extent of the amount undertaken to be contributed by them to the assets of the company in event of its being wound up. Fifth, capital clause. It is a clause which states the amount of the share capital with which the company is registered and the number of shares into which the capital is divided and the amount of each share. It states the limit beyond which the company cannot go. Sixth, association or subscription clause. The association clause generally works in the following form. We, the several persons whose names and addresses are subscribed, are desirous of being formed into a company in pursuance of the Memorandum of Association, and we respectively agree to take the number of shares in the capital of the company set opposite our respective names. Each subscriber to the memorandum should pay for the shares for which he has subscribed. Now, let us discuss alteration of Memorandum of Association. First, alteration of name clause. Section 21 provides that the name of a company may be changed at any time by passing a special resolution at a general meeting of company and with the written approval of the central government. However, no approval of the central government is necessary if the change of name involves only the addition or deletion of the word private, that is when public company is converted into a private company or vice versa. Procedure to do this. The application for change of name is required to be made to the Registrar of Companies in Form 1A along with the prescribed fees to ascertain availability of the name. The period of validity of the name so allowed is 6 months. The change must be communicated to the Registrar of Companies by filing Form 23 prescribed under the company's central government's general rules and regulation within 30 days of passing thereof. The change in name shall be submitted by the registrar in the light of guidelines prescribed by the central government in this behalf. Change by ordinary resolution. If through inadvertence or otherwise a company on its first registration or on its registration by a new name has been registered with a name which in the opinion of the central government is identical with or too closely resembles the name of the existing company, the company may change its name by passing an ordinary resolution and by obtaining the approval of the central government in writing under section 22. Again, the company may change its name by following the aforesaid procedure, where an application has been made by a registered proprietor of a trademark and in the opinion of central government the name is identical with or too nearly resembles trademark of such proprietor under the Trademarks Act 1999. The Registrar of Companies will enter the new name on the register in place of the old name and shall issue a fresh certificate of incorporation with necessary alteration under section 23 subclause 1. The change of name becomes effective on the issue of fresh certificate of incorporation. The Registrar of Companies will also make the necessary alteration in the Memorandum of Association of the company under section 23 subclause 2. Second, alteration of registered office clause. The change of registered office may include number 1. Change of registered office from one place to another place in the same city or town. Second, change of registered office from one town to another town in the same state. Third, change of registered office from one state to another state is possible by alteration in the Memorandum of Association. The procedure to do this includes: first, for the alteration of this clause, a special resolution should be given by the company under section 17 subclause 1. An advertisement should be given by the company in the newspaper for the declaration of the change proposed to be made, and also a notice to the state government as per the Rule 36 of CLB Rules 1975. All the shareholders should be informed about it by the notice. Second, the alteration of the provision of Memorandum of Association relating to the change of registered office from one state to another state shall take effect only when it is confirmed by CLB on petition, that is section 17 subclause 2. Third, the Company Law Board, that is CLB, before giving confirmation to the alteration must get itself satisfied that the sufficient notices have been delivered to every person whose interest will be affected by the alteration, and that the opinion of the creditor of the company has been obtained or their debts or claims have been discharged or secured under section 17 subclause 3. Fourth, the Company Law Board shall cause a notice of the petition for confirmation of the alteration to be served public on the registrar. The registrar will then give a reasonable opportunity to appeal before Company Law Board and state his obligation and suggestion, if any, with respect to the confirmation of alteration under section 17 subclause 4. An order confirming the alteration must be given by the Company Law Board on such terms and conditions as it think fit under section 17 subclause 5. Next, a regard is given by Company Law Board to the right and interest of the members and creditors of the company under section 17 subclause 6. Seventh, a certified copy of the order of Company Law Board confirming the alteration must be filed by the company with the registrar within 3 months from the date of order, along with the printed copy of Memorandum of Association, section 18 subclause 1 subclause A. The certificate will be conclusive evidence that all the requirements of the Act have been fulfilled under section 18 subclause 2. All the records of the company shall then be transferred to the Registrar of Companies of the state in which the registered office of the company is transferred under section 18 subclause 3. The alteration becomes void and inoperative if the order is not filed within 3 months under section 19. Now let us discuss about the alteration of object clause. Section 17 of the Companies Act 1956 empowers a company to alter its article by passing a special resolution. A company may change its object clause in so far as it is necessary for any of the following purpose. First, to carry on its business more economically or more efficiently as per section 17 subclause 1a. To attain its main purpose by new or improved means, section 17 subclause 1b. To enlarge or change the local area of its operation, section 17 subclause 1c. To carry on some business which under existing circumstances may be conveniently or advantageously combined with the business of the company, section 17 subclause 1d. To restrict or abandon any of the objects specified in the memorandum, section 17 subclause 1e. To sell or dispose of the whole or any part of the undertaking of the company, section 17 1f. To amalgamate with any other company or body of persons, section 17 subclause 1g. Now let us discuss the procedure to do this. To alter the object of the company, a special resolution is to be passed at a general meeting. A printed or a typewritten copy of the special resolution is required to be filed with the Registrar of Companies within 30 days of the passing thereof. The Registrar of Companies will register the documents and issue within 1 month a certificate which will be conclusive evidence that everything required has been done under section 18. If the required documents are not filed within the specified time, the alteration will at the completion of such period become void and inoperative under section 19. Next, the alteration of the liability cause. In normal way, a liability clause cannot be altered to make the liability unlimited, but still the alteration are done in the liability clause. First, conversion of unlimited liability into a limited liability. The procedure is to get it re-registered. Second, limited liability into unlimited liability. All the members have to give consent and the consent should be written. Next, alteration of capital clause. Section 94 provides that if the articles authorize a company limited by share capital may, by an ordinary resolution passed in general meeting, alter the conditions of its memorandum in regard to capital so as, first, to increase its authorized share capital by such amount as it thinks expedient by issuing fresh shares. Second, to consolidate and divide all or any of its share capital into shares of larger amounts than its existing shares. For example, 10 shares of rupees 10 each may be consolidated into 1 share of rupees 100 each. Next, to convert all or any of its fully paid up shares into stock and reconvert that stock into fully paid up shares of any denomination. Next, to subdivide its shares or any of them into shares of smaller amount than fixed by the memorandum, but the proportion of paid and unpaid on each share must remain the same. Next, to cancel shares which at the date of passing of the resolution in that behalf have not been taken by any person and thus diminish the amount of its share capital by the amount of shares so cancelled. Now, let us discuss about the doctrine of ultra vires. The Company Act requires that the memorandum of association of every company must state the object of the company. The object clause must determine the boundaries and must identify the object in such plain and unambiguous manner so that the reader can identify the field of industry within which corporate activities are to be confined. The company must bind itself to work within the framework of those objects as stated in its memorandum of association and to no other. the activities which are not expressly or impliedly authorized by the Memorandum of Association are ultra vires to the company. Ultra vires is the combination of two words and they are ultra means beyond and vires means power. An act will be said to be ultra vires when it is performed which, though legal in itself, is not permitted by the objects clause in the Memorandum of Association or the statute. These types of acts are void and they cannot be ratified even by unanimous resolution of all the shareholders. Ultra vires act may be categorized under the following three heads. The first, acts ultra vires the director. These acts are out of the scope of the direction of the company. They are not totally void or inoperative. They can be ratified by the shareholders in a general meeting. Second, acts ultra vires the articles of association of the company. The acts will be ultra vires if they are beyond the powers of company given to it by its article of association. They are also not void and inoperative. They can also be ratified by the company by altering the articles through a special resolution. Third one, acts ultra vires the Memorandum of Association of the company. These acts are beyond the powers of company, so called ultra vires the company. They are wholly void, inoperative and cannot be ratified by whole body of the shareholders. Now we will be discussing the implication of ultra vires acts. The effect of the ultra vires transaction are discussed under the following heads. First, injunctions. In case of a company is going to undertake an ultra vires act, any member of the company can get an order of injunctions from the court to restrain the company for going ahead with the ultra vires acts. Second, personal liability of the directors. It is one of the duties of the directors to see that the corporate money is used for the legitimate business of the company and not otherwise. The directors shall be personally liable to make good the amount if any capita is unlawfully disbursed. If the person receiving the money known that he is receiving the payment of any ultra vires act, then he should return the money back to the directors. Third, void ab initio. The ultra vires acts by nature are null and void and the company is not bound by these acts. The company cannot sue or be sued upon such acts. Next, ultra vires acquired property. A company can protect its property acquired by the ultra vires where cut and it has no power in the memorandum to put up the wires. It was held entitled to recover the damages for injury. The last one, ultra vires borrowing. If a person lends money to a company and the company either has no borrowing power or had crossed the limit or the borrowing is for the purpose which is ultra vires, then the contract will be declared to be void. For recovery of the lent money, no action can be taken. Exceptions to this. First, if any act is ultra vires the director but intra vires the company can ratify it. Second, if the act is ultra vires the article but intra vires the company, the articles may be altered to include the act within the power of the company. Third, if the act is ultra vires the company but it has been in good faith for the benefit of the company, the person will be freed from his liability. Fourth, if the company has taken ultra vires loan and uses it to pay intra vires debts, the company will be liable, not the director. The outsiders can sue the company. Okay friends, so in today's session we discuss Companies Act 1956 in a bit more depth. This session had a comprehensive discussion on further topics like articles of association, prospectus, its content and its dating, Memorandum of Association and various clauses in it, alteration procedure of each clauses and doctrine of ultra vires, its implication and exceptions to it. I hope this session has given you further explanation on Companies Act 1956 and will be helpful for all those who want to open a company or are already running it. Thank you.